Welcome back. In this lecture we turn to the first time for the question of business. Where does business fit into our discussion of international law? So prior to beginning the next section, I thought we would take a moment to talk about international business law. Now, international business law is basically that body of law, that set of rules and regulations that governs cross-border transactions, wherever those may occur. International business law also governs the activities of those who do business in foreign countries. Now, international business law has two components. It consists of both public law and private law, meaning the laws of the state, which may regulate companies doing business abroad, or the laws of that will regulate the private transactions of those doing business abroad. So there's really two sources of law. Now, ultimately, when we talk about international business law, it's international law, but with a business focus. So international business law is really about business. So in this lecture, what we're going to do is we're going to examine those aspects, the introductory aspects of international business law. Now, just as with international public law, there are multiple sources for international business law. So as we begin our discussion of international business law, let's look first at that question of where does international business law come from? And as I said, it's a number of different sources. The body of rules and regulations can be found, first of all, in treaties. Bilateral treaties could govern international business. Multilateral treaties, wide-scale treaties, those involving multiple countries, could involve international business. Conventions, which, if you'll remember, are a large-scale treaty that approaches the level of a law when adopted by the member countries. Statutes, governmental acts, national court decisions, and international courts and tribunals, and even international arbitration. Now, many of these international business law concepts, even though they have multiple sources, they arise out of what used to be called the lex mercatoria, or the merchant's law. Now, we'll talk a little bit more about merchant's law when we introduce the Convention on Contracts for the International Sale of Goods. But understand it to mean that in the early stages of globalization, and here we're talking about the 16th and 17th centuries, as for the first time people began to do business not with their neighbors, not with the country that adjoined their country, but across the world, across various continents. So what happened was people began to do business with others who lived far, far away. And once upon a time, business could be easily regulated because you were doing business with someone that you knew. And if someone cheated you on a transaction or failed to pay you on a transaction, well, your remedy to that was simply either to go over to whoever did it and insist on payment, or simply walk away and never do business with that person again, and spread the word to your neighbors. Well, when we got into international business, global business, there were a lot of times when it was the first and last time in which transactions would take place. So we needed a legal framework to govern that. And so merchants together developed a set of rules and regulations that governed how merchants were to behave in international business transactions. Merchant law is based on the customs and practices of merchants, obviously, but others as well. Bankers played a huge role in the early days of international business. Ship owners, mariners, people who sailed upon the sea, all of these individuals had customs and practices related to international business, and they sought to unite those customs and practices into one code, and that code would govern merchant law. Now, modern commercial codes employ many of these same concepts today. In the United States, sales are governed by what's called the Uniform Commercial Code, the UCC. Now again, we'll spend a lot of time in the next section talking about the UCC, but understand that it is the body of laws, and it is the same or similar body of laws in 49 out of the 50 states, and these provide the legal framework for the sale of goods. What constitutes a buyer? What constitutes a seller? What constitutes a good? What constitutes the obligations that the buyer and seller may have? Well, all of these are encapsulated in the Uniform Commercial Code. Now, there is a similar commercial code for international sales of goods, and that's called the Convention for the International Sale of Contracts for the International Sale of Goods. And we abbreviate that CISG, and we'll be spending a lot of time talking about the CISG in the next topic. Now, legal scholars prepared the CISG, this commercial code, under the oversight of the United States Commission on International Trade Law. So it is a convention, a large-scale multilateral treaty that is open to any nation that wishes to sign it. And what the CISG does is it regulates the buyers and the sellers in countries that have ratified the CISG. So conventions, statutes, like the CISG, all govern international business. Now there are other things that govern international business. Just as with international public law, we know that standards of conduct, customs and practices that may or may not be reflected in official standards of conduct, those can regulate business transactions and take on the role of business law. Even where those standards are non-binding, in a private tribunal, in a private setting, a court or a arbitrator may look to those guidelines to judge what a company or business should or should not do under what circumstances. These guidelines are not law, but they do have a certain moral authority. And sometimes these universal standards of conduct can be integrated into the body of international law. Even though they're not passed by a legislative body, they can form a basis for international